great pleasure to introduce Professor Frohnen to Georgetown Law. We've all very much enjoyed reading your book. We've gotten a lot out of it. And so I thought I would start off like I always do. And students don't know this because you're our first outside guest. So that's how I always start out. By asking you about the origin of this particular project. How did this project come about?
Well, it actually began with my nagging George Carey about the need for him to do one more big book before he retired.
All right, so let's stop now and tell the students who was George Carey.
George Carey was a professor of politics at Georgetown for 50 years. He was an important, really a seminal thinker at the beginning of the American conservative movement. He wrote several important pieces along with a fellow named Wilbur Kendall, who was, again, key to what is usually called the traditionalist wing of conservatism. I don't know how much you know the inside baseball on all this or how much we even want to know. But back in the day, I should do my old man voice when I do that. Back in the day, there used to be your libertarians, your anti-communists, and your traditionalists, okay? Those who were either specifically libertarian or some of them call themselves classical liberals. Those who were primarily a part of the conservative movement because of their desire to fight communism. And those traditionalists, they tended to be religious. They tended to be more standoffish about engagement in foreign policy. They tended to be more localist. And this was the wing that George was a part of and that Wilbur Kendall was a part of. And it all got together at National Review, which is William F. Buckley Jr.'s magazine, and they came up with this thing called fusionism to try to work together. But in any event, George and Wilbur Kendall did some important work on American democracy and the problems of mass politics. They also did a slim book at the end, and this is the real irony here, at the end of Kendall's life, he died with several lectures that George put together into a book called The Basic Symbols of American Politics. And in there, they used a term called constitutional morality. And George had used this a lot over the course of his career, and we had many arguments over the decades about what it was, and I won the argument, so I wanted to make more of it, because he began with the idea that constitutional morality had no real element of individual virtue in it. He said it was basically a matter of calculation, that people in government would do what was in the best interests of their group, because that's the natural way that people act. But again, over the course of a couple of decades, I met him 30 years ago through his work as editor of a journal called the Political Science Reviewer, which I edited for a little while too. And among other things, we argued about whether constitutional morality was really moral in the sense of being about individual virtue. I wouldn't say so much that I won the argument as that events did, because it became clear over time that something had changed, so that there was no longer a context within which constitutional morality in the old sense made sense to people in government especially, whichever branch it was. But there was no longer a desire, a drive to do the best they could for their branch. Now, there was a desire to do the best for oneself. So if you see, for example, in the Congress, it makes a lot more sense if you want to be perpetually reelected to, instead of keeping the power to yourself, it makes a lot more sense to say, we're going to solve pollution, enable the existence of the Environmental Protection Agency, and then spend the rest of your career blaming the bureaucrats for every bad thing that comes out and taking credit for that. So on the one hand, you decrease the power of your branch of government, but you increase your own benefits. Okay, and it was that factor that made him sort of see that there actually is a kind of restraint that's being required of people in the political sphere. So when we talk about political constitutional morality, there is an element of virtue. So we argued about this, and we ended up doing an article together, showed up in the Virginia Journal of Law and Politics, on the relationship between this and the rule of law, and eventually he let me talk him into doing a book. And we started emailing back and forth chapters until he died with his part about half done, and then it took me a while to put it together.
So when did you start with working with him on the book itself? Did you say how long ago?
4.5 years, about that.
So it's really not even that, really not that long ago. 4.5 years isn't that long.
No,
The book seems pretty current in its references and even the literature that it's relying on. Like Philip Hamburger's work has only just come out on this, and it's in the book.
Well, one of the reasons it didn't come out right after he died was it clearly needed updating. That's one of the things I did. But I had to piece things together a bit more than I had planned on too. Luckily, he left a very thick record. So I feel confident saying that there's nothing in there that he would disagree with. Except, Carolyn, are you here? Why are you picking on me? You picked up in your commentary on, remember the problem you picked up on? At the end. Well, one of the reasons for that problem of am I trying to present a solution or not? And a couple of the others of you picked up on it too. One of the reasons for that is George thought there was no solution. We've all gone to hell, get used to it. When you reach your 70s, I guess you can do that. We were having an ongoing debate over this when he got sick. And my choices were I could do it the way he wanted, which would be no idea of what we can do looking forward, tack on some sort of epilogue in my own name, or put together something that I think he would sign on to even if it wouldn't be his idea. So it's kind of a hybrid, right? It's not as strong and full-voiced as you might want. I think that's a major reason for it.
So how does this fit into your broader academic agenda?
Well, the book that I want to do after this is called America's Ancient Constitution, which is a riff on J.G.A. Pocock's argument from the Ancient Constitution of Feudal Law, except it flips it a bit. Pocock argued that English constitutionalism was rooted in this myth that the Brits had going through the 18th century, that back in the day, in the forests of Germania, there had been this wonderful ancient constitution where everyone was equal, all their rights were recognized, and nobody messed with us, because we were Saxons or Angles. And then the evil Normans came and brought tyranny, and the growth of constitutionalism is all getting our history back. Okay? Now the irony is, and this is where you and I might disagree, and the basis of the book is that America likes to deny that we have that ancient constitution. We like to present our constitution as having come ex nihilo from the mind of John Locke and a few great philosophers. And everything is a decline from that moment. So if you take a look at that, what it sets up is the idea of the book, which is a huge act of recovery, looking at the Romans and the medievals in particular, and how they developed. And this is where my real interest came in, from working with Hal Berman. Looking at the roots of decent government. And I teach an LLM class for students from other countries, most of them post-Soviet or sub-Saharan Africa, places where there are a lot of troubles. And I always tell them the same thing I told my wife when I was trying to convince her to marry me. The secret to happiness is to lower your expectations. And what that comes down to in this point is, if you're going to talk about decent government, you have to recognize what is necessary for people to live together. And that sort of focuses you in on a very basic understanding of the rule of law and of constitutionalism as growing out of that, as rules for rulers. And if you look at the trend of these things, it's easy to dismiss this all because of all the horrible things everybody has done in the past. The Romans were some of the worst, right? But they had this emphasis on law. which I kind of talk about, George and I kind of talk about in this book. By the way, if you want to look at this, the stuff that's really George is the stuff on progressivism. And when you talk about John Stuart Mill, you talk about that stuff, he had that down. And the stuff on the Federalist, he was one of the most important thinkers on the Federalist, I think, of the last 100 years. But in any event, so it's a look at the different sources, the Romans, and especially I want to look a lot more at the medieval sources and, for example, Althusius and the Dutch experience.
Let me tell them a little bit more about Harold Berman. So Harold Berman was a Harvard Law professor who ultimately ended his career at Emory Law School. I was a student of his. He taught a course there every year called Western Legal Tradition, and he was sort of known at the time for having been working on a book forever that was never going to ever see the light of day because it was just this massive tome. And there are people who never published their big works, but eventually he did publish his big work in 2 volumes called Law and Revolution, and it is about a lot of things, but it was to me, what was most significant was how it was a study of what the legal system of Europe was like before the rise of the nation state. In other words, before the nation state system during the medieval times, when it's normally thought of as the medieval times as the, quote, dark ages. In fact, it was Berman's contention that it was actually an extremely rich legal tradition that was happening during that time, in particular since there was no center, there was no firm center, there was a lot of polycentric, even used the word polycentric in the book, there were many centers of law. That actually was, his thesis was, that was actually one of the reasons why liberty ended up developing in the West, because there was no one authority. This was after the breakdown of Rome. There was no one authority dictating you have to do it this way or that way, and then creating all kinds of tyranny. There were competing authorities of all different kinds, all over the place, and in the competition, people could just sort of start doing kind of what they pleased. So this had a big impact on me and my thinking, as a matter of fact, as a law student. And there is a bit of that. When you get to the medieval part of this book, you see this Berman insight.
Definitely.
And you knew how.
I studied with him. I went to Emory specifically to work with him.
He was a great man.
Wonderful guy and brilliant. And the project was supposed to go up to the present day, and it had kind of an odd structure to it. It was actually a Marxist structure. It's funny about it all. But the first 2 volumes especially really kind of changed the conversation about the ability to have order, and even a constitutional order, without having a single sovereign document that itself orders all of society. And that was what really excited me about it.
Right, and me too. That I'd already been working on something like that in my own work, even as a law student. Actually, I have my final exam paper. Paper I wrote for him, and I have to read it. I haven't read it. I mean, somebody gave it to me recently, and I just couldn't bear to read it. So I will now go back. Now that we're talking about it, I know where it is. I'll go back and I'll read it. But I was very interested in my first book, talked a lot about polycentric legal order, which is also very Hayekian, and Fullerian. I told you about that last week about the difference with Lon Fuller between the horizontal and the vertical idea of law. This also is similar to what Berman was doing, only he was doing it historically. And Fuller was doing it more conceptually, and Hayek was doing it from a more economic, political theory basis. So it all kind of fit together for me.
And there's a third approach to that, which is sort of the one I'll be taking, which is a combination of constitutional and political thought of the contemporary era. Because if you look at people like Althusius, you look at the covenant tradition in Britain, and there's a consistency through all 3 of those ways of looking at it. In fact, I would argue, I have argued in the past, that there is a tradition that gets completely squeezed out by all the left-right dichotomy that we always deal with here, which is broadly association. There's people like Althusius, people like some of the early other Protestants. It's also Catholic social teaching. It's also Burke. It's also Tocqueville. It's also Juvenal and Robert Nisbet.
And what are all these folks?
They think emphasize, first of all, the idea that the person is fundamentally a relational being. We're not individuals so much we are collections of our relationships. Second, that societies are made up of these kinds of natural communities that grow out of that relationship, and that's inescapable. If you try to capture that in the political sphere, what you end up doing is, yes, you harm those associations, but the other thing you do is you make everything political, and it becomes really impossible to maintain the word liberty by politicizing everything. That makes every choice matter, and every choice important to the public good. And you can't have liberty that way. And I would argue, this sort of following Fuller, that at a certain point, if you're going to try to become that detailed, you lose the rule of law too, because it just can't bear the weight.
One last preliminary question before we start the discussion with the students, and that is, I like to ask authors, since this is a course on recent books on the Constitution, and given there's a choice of format between writing articles and writing books, why did you aspire to write this as a book? Do you have another book that you want to do, as opposed to article or a series of articles, and whether there were any particular challenges of doing something in book form as opposed to other forms?
I naturally write books. I write mostly articles because, frankly, that's how I get bonuses for my law school, and I got kids in school. I have 3 books that I want to work on that I've been putting off because I've been collecting bonuses. And I'm more than a little upset with myself, but the kids are still in school. So I love doing books because you get the sustained argument, and you see the plan come together. And frankly, even if it doesn't sell well, I think you get more attention to your argument. I don't mean, out in the greater public, but I think people who bother to actually look at it will expend more time on it. That, I'm afraid, happens in most of the law reviews, which tend to get dumped into Westlaw and looked at when people are padding their footnotes. And that's always been my fear about law review articles. Might be different here in the big leagues. But those of us who mostly end up publishing in third-tier law reviews, that really is how it seems to be. And in terms of breaking through to the first tier, I haven't done it. It's only in the conservative secondary reviews have I been at Harvard, Georgetown, Virginia, or anyplace else.
Well, so normally I would just say who has something that they would like to start off with, but I think I'd like to go back to Caroline, since she's already been identified here. Caroline,
sorry,
your critique had a particular take, and more beyond what everybody else has already heard about. So could you just explain what the tension you saw that was in the book, and so everybody can bring you up to speed?
Sure. So as I sort of read the book, I picked up on 2 related but parallel arguments. One being descriptive, that sort of constitutions have to work in conjunction with the cultures that underlie them. And one normative, which was that the culture and the culture that underlies the constitution that we currently have, was a good one. And I found that throughout the book, often those 2 arguments overlap and supported one another, but occasionally they diverged, and they especially diverged when it came to the question of where do we go from here, what do we do about the problem that our unwritten and written constitutions don't match. And I felt that the descriptive argument, sort of the natural answer, would be, well, if our current constitutional morality doesn't match our Constitution, then perhaps the Constitution should change. But that conflicts with the idea that the Constitution is a good one, as was the morality that underlied it. And I think there was a tension in the book as to how to best sort that out.
It was great. It was interesting because and other people sort of said similar things about there's something seems to give here, because if your Constitution is supposed to align with your morality, and then the morality changes, and then you seem to, at least George seemed to despair of ever getting back to the old constitutional morality, then isn't this an argument actually for a living constitution that will now change to reflect the existing morality? But that's in tension with what Caroline points out to be the normative argument on behalf of the mediating constitutional morality. So there you have it.
Yeah, yeah. And I hate you, and I'll never speak to you again for embarrassing me. No, it's a very good point, and the only thing I would do is I would add to it that I think is actually even worse than that. Which is to say that the real problem is, if you read the book, perhaps it doesn't come through as clear as it should. But one of the critiques is that this new system can't work. Okay, when I've given talks on this before, especially to professors, their response is, well, what is it that you're talking about we're devolving into? And the closest thing I can come up to is France, which when you talk to most conservatives is an insult, but when you talk to most liberal professors, they're like, what's your problem with that? I mean, we could all use with a nicer cut suit and some better food. But if you notice, the French constitutional order is not as law-bound as ours in the same way. The president gets to issue decrees in a large number of areas. So a lot of it's detailed, but it is different, and it is not, certainly not the system that we would be comfortable with. For one thing, they don't have entrenched individual rights. Okay, so it's certainly not ours. But the other point of that would be that this isn't working. Okay, George's real point, if we had left it with George, if I'd run with that, he'd say, and it's all going to come tumbling down because of entitlements and identity politics. And then we're going to be left with anarchy, and then we're just going to have to pick up the pieces. That would be George's point. And I think you can sort of see how the book leads to that point, because we say, you know, law is trying to do more than it can. That's why you've got quasi-law. And the problem with quasi-law is it really can't control political actors enough. There's too much discretion. This leaves us open to a lot of things, like, for instance, Congress not being able to do anything. And that's not sustainable in the long run. So how could we do this? A sort of living constitution? Yeah, we could just decide, you know, really this needs to be done by a president who's got very broad powers to rule by decree and a Supreme Court that will keep them in line. Okay, you could make that decision, but I think that's an intrinsically difficult situation that, even though it's where things are going, I don't think Americans themselves would be happy about where their own constitutional morality is leading. Okay? The other side of that, and what I tried to add with this is, it is true that the two have to match one way or another. And that's not always meaning that it's a good thing. Sometimes the match is, you got a constitution and the culture sucks. Post-Civil War, okay? The culture in the South, post-Civil War, was too violent, too racist, too filled with anger, to be easily brought within the constitutional order. Okay, so we could have all kinds of debates about, you know, so what do you do with that? Okay, your choices are, you just let them go off on their own and have a separate culture. You can try to impose this militarily, which means you're going to have a guerrilla war and an occupational force for many decades. Or you try to come to what I would argue is actually what the framers of the 14th Amendment tried for, which was to enforce very specific and very narrow, in my view, procedural rights to try to give everybody, and that's, you know, white Republicans as well as freed slaves, a fighting chance to be heard. So the point of it all is, when you've got this conflict, what you've got is tragedy. And there's no political thought, certainly no, one of the points of the book, again, lower your expectations. One of the points is law can only do so much for you. And so, in the end, the point that I'm making, I mean, George and I are actually very different. He believed in natural law, but he did not believe in a personal God. I'm heavily Catholic. So, I mean, we had some differences here, right? So I obviously would take a much more full-throated cultural argument that what we really need to do is change around our views on things and work on these fundamental natural associations and try to build up from there. So there is a tension in there. I'm not sure it's avoidable, and I'm not sure that I would want to avoid it, although I certainly love the fact that it's picked up on.
Given your focus on the importance of office holders defending their church for their institutional interests as allocated pursuant to constitutional design, I am surprised by your opposition to presidential signing statements that notes constitutional objections. Specifically, I mean, appropriations bills frequently contain provisions that, pursuant to bicameralism and presentment requirements set forth in Article 1, violate the Constitution. The President signs the appropriations bill, and he says, oh, by the way, this provision is unconstitutional. It goes into law. As far as I can see, he is asserting his institutional interests while recognizing that a constitutional regime pursuant to which a president vetoed appropriations bills every time they came up because one provision was unconstitutional is ultimately unsustainable. Building on that, I mean, President Bush's objections to various provisions that, in the view of certain people within the Office of Legal Counsel, including John Yoo, incurred upon the President's Commander-in-Chief powers and vesting clause powers. President thinks that something is essential to the national defense. If it doesn't get enacted, country is going to plunge into anarchy and chaos because we're going to be attacked by terrorists. Everything's going to fall apart. Recognizes that there are features of this measure that incur upon his constitutional power. Because he has a duty to take care that the law be faithfully executed, which includes a duty of constitutional interpretation, he says, I'll go all the way with this, except for this provision which incurs upon my constitutional powers. You present that as an affront to the rule of law and an act of abdication on the executive's part. Why isn't that a laudable example of the president standing up to a Congress that's asserting its constitutional powers in a way that detracts from the Constitution's design?
Okay. I think it's an utterly predictable result of the allowance of the death of appropriate legislation coming from Congress, which is to say, you're right, there's this threshold issue. Frohnen wants the president to do something that's never going to happen. And today, it probably isn't, which is that these 1,000-page omnibus bills are not law. They're not. I don't care how detailed they are. They're not law. I've helped write them. They're conglomerations of policy statements stuffed together in the hopes that something will fly and it'll get worked out by the bureaucracy. They don't have sufficient detail, they're not sufficiently consistent, they don't signal properly. Okay, a law is supposed to be something fairly discrete, not a code. We're not a code country, although we're becoming one. So the problem was that this was allowed, and you know, again, both sides are responsible for this. I feel like I'm causing you pain right now. Both sides are responsible for this. But the appropriate reaction is not to let it go there. Okay, Reagan actually, a huge jump in this was when Reagan came in, trying to get his budget cuts and the tax deal at the same time. So is it understandable that the president would do this? I got to do my job, so I'm just going to take back what I can. Sure, and some of them did it more honestly than others. W was always ducking the idea that he would have to actually veto something, so he always did it surreptitiously, and that he was particularly egregious about it because he used it as a means of policy implementation. But the main problem is, it all goes back to Congress. They stopped doing their job, they stopped writing real legislation, and instead they passed these things, and the president has gone along with it. I mean, back in the good old days, presidents vetoed legislation because it was unconstitutional. That included the form. So what I say is the key problem here is legislation is being passed that is not in the form, the appropriate form of law. And if it has these unconstitutional provisions, you should veto it. Now, does that mean that one way of salvaging this might be to have a line item veto? Yeah, I wouldn't be against it if it were to be passed as a constitutional amendment, but I don't know that that will solve the basic underlying problem, which is the atmosphere within which the president's conduct does look like mere self-defense. And sometimes it is, sometimes it isn't.
Two quick follow-up questions. One, are your claims about the fact that these are not law claims about its original meaning, specifically about legislative powers, textual, or are they predicated upon a thick theory of law that is consistent with the Constitution but is not actually embodied in it? Because I think that if the answer is no, then what you're ultimately doing is saying that the president or Congress can't adhere to their constitutional obligations without adhering to a sectarian theory of the rule of law that's not constitutionally required.
Okay. The majority of this is because of delegation, which I've made very clearly. Maybe are you saying that the theory of delegation that you've got in here is a sectarian view?
Well, I happen to largely agree with it, but the perennial problem is drawing the line between an exercise of legislative power and an implementation power that, insofar as the executive is charged with enforcing the law and has certain rules and proceedings that it follows in the course of enforcement, it doesn't amount to legislative power to specify those rules and organizing principles.
It usually does. Which is why, historically, the way this has been done, the way the Brits did it, was you actually have legislation, Congress has to pass on the particulars. If you're going to work it out, it's a problem to have an agency doing that, even according to the Administrative Procedures Act. Because they are in fact engaging in lawmaking, just according to rules that are set down for it. So that's a problem on there, but I'm not just talking about that. Is it a thick theory of law? Somewhat. I would say that it's an implication of Fuller. At a certain point, legislation becomes too complex, too multifaceted, and too inclusive of contrary purposes to be doing its job of signaling to people what's expected.
Yep, James.
So I think when I was reading the book, it seems to me that you ultimately present a choice between two governments. One is basically this commanding authority that will enact certain, say, moral visions of what society can and should be. And the second one, which is this mediating constitution, but its vice will be that it effectively will allow for the institutionalization of whatever vices society has. And is the answer really just that, of course, like law should not be the medium through which you change society's vices to virtues?
No, that's a good point. I think a central assumption of this, which if it's not spelled out clearly enough in the book, it should be, is that law by nature follows culture. If you try to have law lead culture, it's going to be ideology and it's going to cause a lot of troubles. Because it's not going to be played out, it's not going to be developed through the actual lived experiences of the people. It's going to be based, well, it's going to be French Revolutionary, right? It's going to be commanding. I have this idea of what's right, and now I'm going to make everybody else live according to it.
Right.
So yeah, from that perspective. Now, obviously, you have, each has their own weaknesses, each has their own problems, and this brings up, that complicated issue. What happens if that underlying culture has changed? Right, the most fundamental change, which you all are too young to know about, has been the sidelining of religion in American public life. And we think of that as just this thing where we've gotten some of the crazy stuff out. But no, we're in a completely different world from 50, 60 years ago in terms of the way people live their lives. And you may like this world better, and that's fine. But it has changed fundamentally cultural understandings. And does that mean then that the Constitution no longer works? I think we're getting to that point. And if you think, well, then too bad for the Constitution, my question for you is that what are you now going to do for a governing document? Because you don't have one right now. And it may be okay for elite law students who want to lead a certain kind of life. May be good for social justice warriors, but it's not really good for especially poor people not to know what the rules are.
I just wanted to put a footnote in as to illustrate how much things have changed in terms of the religion and public life. Two different sort of anecdotes. One is when I was in grade school in second grade, we had an annual, in our public school, we had an annual Christmas pageant or at Christmas time, and I played one of the shepherds to kneel at the manger of baby Jesus, and I'm Jewish, so that was just a normal thing to do. So that was, and then the second thing was, is many, if you watch television, the situation comedies, Fathers Knows Best, or just name them, many of the scenes were kind of routinely set where on the street where the family was coming to and from church on Sunday. So the family was coming back from church, and the little boy runs up and said, "This is happening, and let's go here, let's go there." But the fact that the family was coming to and from church on Sunday was just so normal that it would be depicted as just another place to set a scene in a situation comedy back in those days.
Now that would be controversial.
No, that would just be like saying they were on their way to and from a restaurant. It was just so normal that would be so. But now you would think like that was a really big statement if you had a show in which anybody was even depicted coming back from a church on a TV show. That would be like the show would be about whatever it just happened, right? Because the church was involved somehow. Caroline?
I just wanted to, I'm sort of stuck on this sort of where do we go from here? And based on something you just said, that you don't want law to lead culture. And I guess my question is, if we're trying to keep the Constitution we have, and your solution would be to then change the underlying morality, isn't that exactly what's happening? Isn't it the law that's enshrined in the Constitution is leading our culture?
Good point, but I would disagree with it to this point, to this extent. You can paint it as an evil cabal who conspired to change everything, but I don't think it was purely a matter of law and constitutionalism that characterizes the progressive movement. I think what you had was a very systemic and seismic shift among American elites over the course of a few decades. And between that and specific things that were not sold as making these kind of fundamental changes at the time, you had us falling into a different conception. Some of that was on purpose. Some of it was the progressives giving the idea that they weren't in fact going to do anything monumentally different, but they were going to empower the people more. You talk about this in your last book. The rise of the new Democrats. That was part of it. Part of it was simply responding to emergencies in a particular kind of way. The New Deal. Okay, so a lot of things take place. I mean, life happens, shifts happen. But part of it was frankly allowing for a different ideology to take root and become dominant. Now, the question of what you do at that stage, a lot of this has to be a defensive posture. It has to do with Little Sisters of the Poor and other organizations trying to give them space to survive and perhaps flourish.
Yeah.
So,
Could you guys get your 10 cards up so that we can read them up here?
I won't be able to read them anyway, so it's okay.
They got curved.
basically, picking up on the fact that both your book and Professor Barnett's book almost kindred spirits in the fact that they address the same problem, and timelines are similar, where things change more or less, sort of similar. I went through your book, at least the conclusion, a couple of times. Well, there is you do flag that this is a problem. This not much by way of a solution, in the sense that you do say that you've got to sort of reevaluate, and the other thing is you also acknowledge that, for example, any practical solution, so to speak, which listed is probably not going to work. But I couldn't help but compare. This is where, so for example, with Professor Barnett's conclusion, he says that these are the steps we've got to take. This is how we've got to take them. This is where it's going to get us. Given that it was so similar, I had difficulty reconciling the fact that,
Why couldn't I do what he did? We have a different moral anthropology. I think that's fair to say. I would argue that these things are much more rooted in religion, by which I mean binding, not just the faith, but the faith practices of the people. This has to do with traditions which take many generations to develop, or even though they can, it takes a long time for them to atrophy, but they can be smashed pretty quickly. One example I would give of this is no-fault divorce, which was passed, and nobody throw anything at me, well, nothing too hard. No-fault divorce was sold by the lawyers as something that would have no impact on people's lives. All it would do would allow a few people who hated each other anyways to stop having to pretend. Okay? It would have no real impact. If you look at the way it was sold, that's what was done. Lo and behold, in a very few years, you went from divorce being a tiny percentage of marriages to being 40%. That first jump was huge, and it was in a matter of single digits.
A lot of people that hate each other, apparently.
Yeah. And that may be true, and we may be happier that they're gone. But my point is that institution was fundamentally changed by that one little switch. Okay? Cultures can be destroyed.
I was a little surprised to see Neelish's comment, which he had in his paper, comparing us after last week, or 2 weeks ago, when I was actually teaching my own book, when I said that one of the reasons I have these programmatic proposals at the end is because the publisher wanted me to have programmatic proposals at the end, so I felt I had to have a programmatic proposal at the end, so I did.
Nobody told me to.
But because mine's a trade book and yours an academic book, so there's a big difference there. So the difference is partly explained. I've kind of already somewhat explained that. And there's a secondary reason why I think it's a good idea for a book like mine to have that, and that is that when people read the book, for a trade book, you're hoping the public will read it. At the end, the first thing they really want to know is, what can we do? What can we do? What can we do? What can I be for? And I'm not necessarily that any of that will actually happen, but they really want to know. You figured this, you got this problem, so what should I be for? What should I be? Here's what you should be for. You should be for this. You should be for this. And if enough people agree with that, then something good will happen. So that's the other logic behind my proposals. But the other thing is I thought when I was reading your paper that our approaches with respect to step one are pretty similar, and that is that if you think one of the problems is that, and who was it that said that I was equating, were you the one that said that I was equating the modern Republican, well that was your last week's criticism, that I was somehow equating the modern Republican Party with the original Republican Party? I don't, but the whole idea here is that by writing a book, the hope is, of course, probably fleeting, but at the margin, you'll change people's attitudes about, being a Republican or something, what the Republican Party ought to be, not what it currently is. So at the margin, if you're faced with a cultural problem of some kind, all people who write books can actually try to accomplish is affect the thinking of the people who read their book. That's really the immediate effect, and their book is doing that as a first. That's got to be a necessary, if you think the problem is somewhat the belief system of the general public or a majority of the public or a significant minority of the public, and you want to affect that, you write a book in order to affect that at the margin, and that's what they've done. And that was step one in my proposal, which is remember have a Republican narrative. Remember the story as it actually happened, not the one you've been told these days. So in that sense, we're kind of similar.
Which I did point out that, at best what it does is it's step one.
Yeah. Step one is very similar between the two books.
And I guess the other thing I'd say is if you want to look at step 2 and 3 for mine, there is another book that I might recommend you look at, but it's not law. And remember, one of the basic arguments I'm making is that we put far too much emphasis on law. But the other book would be Rod Dreher, who is a Russian Orthodox recluse living in Louisiana, did a book called The Benedict Option, which just came out. a few months ago, which is all about rebuilding community. And that would be where I would argue the focus has to be in terms of what lawyers and judges would be doing. I really don't have that much in terms
The
of...
Benedict option, I haven't read the book, but I've read about the idea, is a withdrawal essentially from politics and throwing yourself into building local community, establishing relationships, working in some sense, devoting your life to from the ground up, rather than trying to affect the political culture around you, which is, one person has a hard time doing. Is that a fair assessment?
If you don't mind my tweaking it just a little bit, I think that's great.
You probably read the book.
The one little tweak would be, you still have to engage in politics, and I know Drew pretty well. We argued about this for years. I won. But people always claim they won, right? The one tweak I'd have on that is, you still have to be engaged in politics, just don't expect too much of it. Engage in it as a defensive maneuver, trying to maintain space for your own communities. And I would say that, they approach the law, I think we try to push back, and as much as possible, leave space for more natural associations to do their job.
Sam?
When you get into the substantive due process cases, it seems that your main criticism is that are relying on penumbras, or I would imagine in like Roberto recently, in Mysteries of Human Life, that it's undermining the rule of law because it's not tied to text in the Constitution.
Mm-hmm.
If those cases would have been decided the same, but if they would have picked one, and if they would have just grounded it and say the Ninth Amendment, would that have been enough to uphold, in your view, the rule of law, even though it wouldn't be able to point to a written out right, but if it was grounded in an amendment?
If you're asking me, do I think that substantive due process has grounding in the Constitution or the amendments? No, I don't. Neither did George.
Okay.
That said, there are specific things in the Privileges and Immunities Clause, procedural, allowed to give evidence, allowed to sit on juries, access to courts being key to this. But yeah, it's much thinner and much more reliant on federalism as the check.
Jesse, you want to talk about what your critical comment was? Because it's sort of related to this.
Yeah, sure. Well, okay, so mine was on judicial review and substantive due process, and it seemed like, well, first you distinguished modern day judicial review from judicial duty as it was originally known, but it seemed somewhat like judicial review was essentially just judicial duty, but judges ignoring the constraints.
Oh, so was judicial duty run wild or something like that?
Yes.
That's what you said, I think. It was just something like that, run riot or...
That's probably true. It was really hard time.
So the problem, I mean, I think is, I think maybe you'll remember your paper, I summarized it a little bit for you. Is that if there wasn't anything wrong with the function the judges were performing, what was wrong is they were going beyond what they are actually textually authorized to do in the performance of that. So they really are probably better off being criticized for getting the Constitution wrong and doing too much or making up rights, as you put it, rather than just the fact that they would be invalidating laws per se. So is that
yes,
fair?
That's very fair.
Anything more that you remember that was in there?
Well, I also substantive due process and its connection to order of liberty, where by judge, I somewhat disagree with your argument that it was primarily judges' activism that led to the change in constitutional morality rather than their application of duty. I mean, you do mention the delegation doctrine and how they dropped the ball there. But it seems that the activism is just the judges essentially getting the law wrong, but there's still a role for judges to uphold individual rights under the Constitution. And the failure to do so undermines order. And I would use as an example the Reconstruction period, where individual rights were not being upheld and there was no order.
Oh, there was plenty of order if you were a rich white landowner. But it wasn't the rule of law. That's why it had to be defended in significant measure through political violence, racial violence. I see what it is that you say. That is, aren't I demanding that courts abdicate, or George and I demanding that courts abdicate their role as defenders of individual persons faced with state power? And, there certainly is something to that argument, because I would say that the Bill of Rights was not incorporated through the 14th Amendment, so that seems to limit things an awful lot. But I would also argue that if read properly, and this, this is Berger. I mean, I really think the documentary evidence is, I would side with that documentary evidence. Guy wrote a book called, and now I blank on it. What's that?
As government budget.
Yes, thank you. But if you look at the real elements of due process, all right, they provided the basis from which people would have had, in fact, free slaves in particular, would have had a chance of building something, provided this federal government was able and willing to enforce them. They weren't able or willing to enforce much of anything. That's why they eventually left and went home. That's the tragedy. Would it have been less problematic to say, no, I'm sorry, the courts are open to everyone. There's a little thing called, well, this is actually equal protection. You have to apply it to them. You have to allow them to, whether they're black or white, former slaves, whatever it may be, people have to be allowed to give evidence. You can't have juries where you're corrupting things, right? The famous story of Hugo Black, how he got started, which was ginning up racial hostility in his own cases, right? These are the sorts of things that I think are really important, that I think are actually the fundamental basis of a decent society that still weren't done. And I think you can make a strong argument that if courts had actually focused on doing what they need to do, what is in their central bailiwick, providing justice to those in front of it, vindicating the reasonable expectations of the parties, that's how I phrase it. I think that's what justice actually means in a court. You'll have a lot more good being done than by trying to do something that just isn't being accepted out there. Does that mean that these inequalities aren't bad things? No, it means that law isn't magic. So, again, I teach students in my comparative common law class. We deal a lot with the system in India, where you have hundreds of millions of people who are completely disenfranchised, who have no chance of ever getting a case ever heard. So the Supreme Court says, all right, send us a letter. We'll set up a system where you can get heard no matter what. All you gotta do is send us a letter and we'll take care of that pollution. We'll take care of those people who are trying to move you off the sidewalk. And in very specific cases, sometimes they do some good. But it's like a drop in the ocean. It's much more important to develop a system.
If I can just follow, this is the one substantive question I'm going to raise, I think, today, which follows up on what Jesse was saying. If you assume that what the courts were doing before the New Deal were identifying special rights and protecting them, then what they're doing looks a lot like what you condemn the Warren Court or the more recent court for having done, making up rights and protecting those workers' rights. So that's a very rights-centered focus. But what if that isn't really what was going on? What if you read these cases and what you see they were doing is they were scrutinizing statutes to see if they were laws, in your terms. They had a thicker theory of law than Oliver Wendell Holmes did, who basically said as long as you get a majority passing it, that's a law. So their thicker theory of law included the use of laws that were irrational or arbitrary, but in the following sense, not bad policy, but irrational insofar as means were chosen that didn't really relate to an end that was within the competence of government, even general government, or arbitrary insofar as it was treating different people differently in a way that was not justifiable. Even if you put a thumb on the scale for the government, which the court tended to do, what they were actually looking for was whether statutes were law-like. So if you grant me that as a fact, because you don't have to, you can say, well, that you dispute the facts, but if you grant me that as a fact, why isn't the judiciary at that point really doing something that's within the judiciary's bailiwick and attempting to keep the legislature within the legislature's bailiwick, which is in a way that you ought to find congenial to your thesis about law?
Okay. I will grant you that that is some of what was going on, as a matter of fact. I would agree with that. I would say it's a minority of what was going on because they were also trying to create national markets. There were all kinds of other things going on. I don't think, in general, I think the real problem with this was insufficient recognition of the limited reach of federal constitutional provisions. But yes, if that's to the extent that's what's going on.
Let's put that to one side. That's the
Yeah,
interpretive
to the
question.
extent that that's what's going on, that is in fact their job. And if that is what's going on, whether the substance is right, whether they're looking for personal rights which aren't in fact incorporated, and so on. Again, I think we may have arguments on the margins of that. And I am not one of these people who wholesale says everything that went on in that period was just a capitalist plot to try to enforce some crazy system. No. But when I talk about the need for restraint, in some ways we have too much restraint now. So much of what the court was doing in this era, I didn't have a particular problem with. It didn't all turn out rosy. But that wasn't the focus of that section of the book either.
Well, it was a little bit when...
Yeah, a little bit. And I would maintain the disagreement a little bit.
Well, no, it was only a few pages, so that's one reason I wasn't not sure I was even going to say anything about it until we got to dinner.
Indigestion already.
I would just humbly suggest that you reread the majority opinion in Lochner, and with this in mind, that really the form of reasoning that the court engages in Lochner is there a legitimate, is there an end that this legislation, not the whole legislation, because the whole Bake Shop Act was basically, the court said was correct, it was fine, it was a health and safety law, but with respect to the maximum hours provision, does this relate to an end that's within the competency of government? And if it doesn't, which would be health and safety, and if it doesn't have a sufficient relationship to health and safety, we're going to assume it may have been passed for other motives, which turned out to be progressive motives to aid unions. And in a particular union in this case. And it's arbitrary because it's going to be applied, this theory that has been offered in defense of the statute is being applied to bakers, but it could just as easily be applied to all these other employees who it's not being applied to, which again suggests that it's being introduced for other motives. So that is the whole. And it's true that there's freedom of contract mentioned in the case because, in fact, the issue is whether there is a threshold issue as to whether the parties have acted wrongfully or whether they're acting within their liberty rights, which you have to take as given before you reach their regulation. But when it came to the reasonableness of regulation, it seems to me, this is why I think it's so congenial to your thesis. And that's why I don't think that we're necessarily at odds here. The court is trying to hold the legislature to making laws, as you would think a law should be, and not doing an edict to help, in this case, what would be a pro-union, progressive political agenda.
I will have to think about that some more, in particular with the details, but I will put forward this concern, which is that I think the term arbitrary can be too plastic, and I would reference the word absurd in current jurisprudence as the danger.
Well, in that case, I would say you're imposing your own extremely low standard for legislation to have to jump across before a statute can be called law. Your whole point is that law matters, and law has a normative content, an internal morality of law, and something that's not just because something's a statute or just because something is a regulation or an edict doesn't make it law. I'm making a very simple point, and I agree that the courts weren't always doing this, but at least in the most famous case, which conservatives love to beat up on, Chief Justice Roberts in particular, which is Lochner v. New York, that seems to be what they were doing. They were asking whether this was truly a law, or whether, in which case, if it was, then Joseph Lochner was being in jail for not paying a fine, and he was not being deprived of his liberty or property without due process of law. But if it was not a law, if it was merely an edict or a statute that did not share the qualities of law, then he was being deprived of his life and his liberty and his property without due process of law. And so you could disagree. There's a separate question, this is the Raw Burger type question, as to whether any of that is justified by the 14th Amendment. That's a separate question. I think it all is entirely justified by the 14th Amendment. But set that aside. Now I'm just talking about the role of these governmental actors that we've spent so much time talking about. It seems like they're operating within the role you want them to operate within.
Well, I mean, you've cut so much out of this. I'm in this small area of, and all I'm saying is that I'm actually saying you may have a point, but that I remain concerned that when judges engage in moral reasoning beyond a fairly low threshold, whether they call that moral reasoning about what is arbitrary or what is absurd or what is fundamentally just, it quickly goes beyond their training and their capacity, and it goes into policy making.
We don't necessarily disagree about this, just so you know.
Well, and again, I think this is a matter of degree, not of kind. The disagreement I think we're having.
Simone?
Yeah, while you two are in conversation, when I was reading about association, how much impetus you place on that, both socially and structurally for the United States, I thought a lot about reading Professor Barnett's book and how important he sees individuality and we the people that stands for individuals. And I'm wondering if you think that having that sort of importance on associations requires a rejection of individuality in a way as the basis for the Constitution, and if so, why?
It is a different moral anthropology. Does that matter? We'd have to look
Can
at
you say
particular
what you mean
cases.
by moral anthropology? Because I'm not sure I know what that means.
I think that I do not believe in individuals. I believe in persons. And what that means is I think that every person is largely a product of their relationships. I'm not an individual. I'm a husband. I'm a father. I'm a professor. I'm a Catholic. All these things define who I am fundamentally. Is there a free will? Yes, but that in itself is constrained so much by the places where I come from. You know, it's not unimportant who my parents were. It's crucially important. How I grew up, crucially important. That all these things define who I am and continue to be the most important parts of my life. And that is the natural status of persons. That's how we become full human beings and how we maintain our capacity to act as moral agents. Given that, individuality in the strong sense of defining societies according to their protection of individual rights is just not the lens through which I would look at things. If you looked at the kinds of policies that I would want in relation to someone on the political left, by the way, I'm on the political right, just in case anybody didn't pick up on that.
I think they got that.
They would be far closer to Dr. Barnett than they would be to Bernie Sanders. Okay? On particular policy positions, we probably agree on nine times out of 10 on what we want, certainly at the federal level. But again, for me, the main point is allowing space for local associations, including many which are, I would emphasize, involuntary. I did not choose who I would grow up as the child of. I did not, in an important sense, choose to be a Catholic. I was born into it. It shaped who I am. I couldn't imagine being anything else. So many of these associations aren't really voluntary. They're who you are. Could I leave them? Yeah. But most of the people, most of the time, don't. So I think that fundamental, and I wrote a book on this, okay, so stop me immediately. The purpose of government is to protect and foster the more fundamental associations of society, because that's where we live good or bad lives. So that means it's a different lens through which you look at things, and it means that when you look at the policies, you're going to be concerned about different things. But I don't think it affects, certainly at the federal level, the understanding of what a constitution is and should do. We could have a very different set of policies, and I'd still say these are what the constitutional rules require.
Gustavo?
I'm listening from Brazil. English is not my first language, so I'll try to express myself. And reading your book, you use virtue and morality. And I remember the class, I'm asking about political theory, the class theory of state, monarchy, anarchy, tyranny, and the cycle of the generation.
Right.
And I want to ask you two questions. First, do you think that the American Constitution, regional, is a mixed government idea? Is based on this mixed government solution for this cycle of the generation? And if it is, what is happening now is that the mixed government is also being degenerated, so the solution was not a solution. We have seen that this idea, British idea, was not the right solution.
Great questions. But yeah, I think it's fair to say that this was intended to be a mixed polity, that the balancing of classes was considered very important. If you look at the construction of the federal government, that's clearly there. If you look at the way that it's played out at the state and local levels as well. I think it's pretty clear that we are devolving into an oligarchy, and are most of the way there. Does that mean that there's a particular failure or that this is inevitable? These are trends, these are tendencies. The thing about that is that assumes that you've got one place that's going to go through all this. But what usually happens is that somebody conquers you, or you break up, or you break off. So there are other ways off. One of the crazy ideas that comes up towards the end of the book is it wouldn't, and George thought this is what should happen. There should be 4 or 5 United States regional governments. When, as he fully expected, and I'm beginning to expect, the entitlements blow up and the central government can no longer afford to fund them, which, look at the numbers, be afraid. I don't know about that. I'm certainly not as convinced as he is. But one result, if you do that, then the game's up. I mean, anything could happen from that point. You start the cycle all again. I think there's a natural tendency of governments over time to concentrate power in the center, because so many things demand it. War being the big one, right? So, yeah, the cycle's there. I think there's a tendency toward it, but poop happens.
Can I follow up with a question?
Let's move on, because we're now at only 45 minutes left, and there's a number of people who haven't spoken yet. So if you haven't spoken yet, if you want to raise your hand. Garrett.
I thought, I was convinced by a lot of the arguments in the book, and especially the centrality of structural considerations. But one of the things that I still remained unconvinced, I touched on in my brief response paper to your book, was that this distinction between a mediating constitution and a commanding constitution, I got the sense that you don't believe that a broad administrative activity like the one that we have could possibly fit within the concept of the mediating constitution. And I wanted to push on that a little bit in the sense that when I think of mediation as an idea, I think of it as setting expectations within which people can act. And while your points about the locus of control are very well taken, I don't think they're necessarily relevant to this breakdown I'm trying to work toward. I can still imagine, at least in some abstract sense, you would expect to have a broadening array of individual expectations that are being set by governmental structures as the economic and social structures in the broader society themselves become more complex. So I like the idea. I had never heard the idea that we could sort of move this under Congress's auspices to make it more legitimate within the confines of our constitutional structure. But that would still allow for the fundamental idea that you could have a larger amount of government influence on the actions of private parties without moving outside of the mediating constitution, right?
Well, for it not to be quasi-law, though, it's going to have to be, most of it's going to have to be at the state level. There's room for some of the administrative state at the national level, but not all that much of it, right? Which is not as...
So why are you saying that? Because of enumerated power?
Yeah.
Okay.
Yeah, in restrictive reading of the Congress.
Got it.
So a lot of it would have to take place at the state level. But when you think about it, states in our country are pretty big too. So it's not as if you wouldn't have that aspect of it. Now, the thing I would say is to the extent that that happens, it makes it harder to maintain being a mediating constitution. And there are outliers on this. For example, you know, I spent a summer teaching in Iceland, and there I cannot think of a more intrusive government on this planet. They tell you what you can name your kids. The doctors work for the government, although they were on strike when I went there. It's socialism, but it's also social democracy. Everybody, there are no last names, okay? Does this function? Well, it certainly doesn't function as well as free markets would. Okay, I was living in a bedroom and a half condo that was a vice president of an international corporation. Okay, I mean, they weren't doing well economically, but they seemed perfectly happy with what they had. Does it function? Did they have a kind of rule of law? They're so small and their culture is so tight-knit. They don't take refugees, by the way, they just don't. Okay. But their culture is so small and is so tight-knit that it did in a way that I would never want to be a part of permanently, but it did function, and people did know the rules. Okay, so it's possible to have the rule of law even in what I would consider an oppressive, commanding constitution. So I'm not saying that anytime if you stray from this, you're going to hell in a handbasket immediately. As to whether you can have an administrative state of any kind and still be a mediating constitution, I think, again, there is a tendency for that to be problematic, but in a lot of the ways that you could deal with it, they start looking a little bit like corporatism, which troubles a lot of people. But if you look in Catholic social teaching, there's some things that I'm a little bit uncomfortable with because they want boards of unions, they want boards of companies. They're all going to cooperate and determine this. It's certainly not liberal, but if you've got a sufficiently tight consensus among the people, I might not be comfortable with it, but I think it would work and it'd just be mediating. So I think a lot of this is actually culturally contingent. And as far as in the American context, I think the main thing is that it'd have to be at the state level.
Someone else who hasn't spoken.
Okay, so my sort of critique, I took the position that, to me, I don't believe that the framers believe their own constitutional morality. I think that, in theory, they looked at different forms of government through history and time and figured, okay, this would be the one that would at least make the most sense for this new government. But I just felt that when you look at slavery, and also you said that a little earlier, you said that you feel that we're moving into robot oligarchy. And I think that to a certain extent, the framers, there were only certain men of certain stature that were even at the table to help frame the Constitution. And so I don't know, for me, it just kind of felt like there are sort of inherent contradictions within the framing of society, and I just wasn't sure. Yeah.
Well, I guess my response would be that I don't see that the existence of inequality and injustice negate the existence of a constitutional morality. They may call into question the higher virtue of the people. And they may cause you to question whether the deal that was set out was fair. But that doesn't take away the possibility that what's being required is self-restraint, defense of one's turf in the interests of the particular institution that you're a part of, in the interest of balanced and limited government. Now, what that does is it says that the various forms of inequality and injustice that you're talking about are a stain on that, or a problem with that, limit the scope of the rule of law and the procedures and justice that are associated with it. But it doesn't say that the structure is not either functioning or not. So if what you're saying is that these people were far from perfect and the system they set up was far from perfect, you're right.
I guess my point was that it just felt like it'd be natural that we've kind of come to the place where we are now, where people are, maybe not natural, but it wouldn't be far-fetched to see that if limits were being stretched then, that they're being stretched now.
Well, yeah, no, that's an important thing. How does a society deal with a fundamental structural injustice of the scope of slavery, right? And different societies have tried to deal with it differently. And the way in which it was dealt with in the United States clearly has not worked out too well for the structure of the system in and of itself. But that goes to what's happened to the Constitution more than what it was. Now, if you're saying that the Constitution itself, when it was formed, should have addressed slavery differently, in the abstract, that's obviously true. In practicality, I don't see any way they could have done it much differently from what they did. There would not have been a national government if there had not been sidelining of slavery. There just wouldn't have been. Now, maybe that means there shouldn't have been. In that case, you would have 13 separate states, and we would have just seen a completely different history coming from that. It's a different question as to how it should have been dealt with. And again, we had some of that talk here. There was a civil war, and then there was a flawed and ultimately failed Reconstruction era, and then civil rights. Right?
One of you, I don't know if this was you, Dennis, or someone else, who made the point about could the mediating constitution have been said to work if in fact it led to the Civil War? If it allowed the Civil War, which one of you made that?
That was me. That's
you want to put your point to everybody so everybody has it?
Yeah, so my question was, it seems like the book takes a very favorable view towards mediating constitutions and an unfavorable view towards command constitutions. But I was just curious, and from my perspective, if you want to call the Constitution a mediating constitution, it needs to be able to mediate between factions. And if, in the case of our country, as it did, a civil war occurs, it's hard to call the Constitution that attempts to mediate factions that then end up going to war with each other. It's hard to call that successful mediation. I don't know if you could have a less successful mediation. So I'm just curious how that affects your view of the original Constitution as a mediating constitution, when it seems like, and I did note in my paper there were many sort of compromises that were reached leading up to the Civil War, but how you view the Civil War in the context of a mediating constitution and whether or not that term even makes sense given what happened.
Okay. It's all Taney's fault. We done? Sorry. Part of me is one could spend a lot of time backfilling this and saying, Taney had this terrible decision which undid a lot of attempted compromise. All well and good. But the truth is, a horrible institution was allowed to not only continue, but to gain in strength. We allowed the southern states, under the guise of states' rights, reach out and harm the rights of others. It's not states' rights to say that I should be allowed to kidnap whoever I want under the claim that they might be an escaped slave. Okay, so that's just, it doesn't work. Okay, but two things on this. You've got a massive dislocation as well as injustice, dislocation that affects the cultures that much. That's a pretty high bar to say that you should be able to mediate that particular one. I don't think many constitutions would be able to take care of that. And once again, think it by wife and lower your expectations. I don't think it's going to be able to mediate everything, and it doesn't mean it's fundamentally flawed because it couldn't handle that particular one. The second one, the more controversial one, is there are a lot of people who argue that the Constitution did have a way of dealing with this. Secession. At West Point, there was a pamphlet that everybody was taught from well into the 1820s that said every state had a right to secede whenever it wanted to. This was an active theory up to the time, obviously, until it was stamped out militarily. Secession, and again, you talk to people from areas where there's a lot of internal conflict. At some point, and in a lot of countries I can think of, including where Americans have troops right now, you got to wonder if the answer isn't, oh, we're just too different to be in one country. Now, a lot of things flow from that. My only point is that at some point you got to decide, split up or internal conquest. It's a problem all kinds of societies face. Does it show a weakness? Yeah, but I don't know what structure could have possibly come out any different, other than if you're willing to say, okay, you should just let him go. So it's a fair point, but I don't think it undermines the model.
It's sometimes useful to remember that the radical abolitionists, not the anti-political radical abolitionists, favored secession as their solution to the slavery problem, because they thought that if the North would secede from the South, then they wouldn't have to enforce the Fugitive Slave Acts. Then slaves could flee from the border states into the northern states, and then eventually slaves could flee from the deeper South into the border, and then, in other words, it would drain the South of slaves without having to go to war if the North seceded from the South. I don't have any idea, we'll never know if that would have worked. But the underlying assumption that the North could secede from the South over slavery was shared by these particular group of radicals. Jason.
At the moment, at least, we are saddled with this fourth branch, this federal administrative state. Is there any worth to, or is it worth assigning any sense of individual virtue to the administrative state that might alleviate its problems or at least create some sort of damage control? And my thought with that is, at least saying the negative, is that you might be just making more of a quasi-law in the sense that you're making this quasi-law, giving it this extra veneer of legitimacy, but it's really just becoming more quasi.
No, I understand what you're saying. That's a great point. I actually have floated, no one was interested in it, but I floated since the book came out, the idea of having textualist commissions within the various branches. What they do is they just go through the regs and say, is this rooted in the actual text of, the Constitution, but I'm actually talking about the actual legislation passed by Congress. Can we find that this is consistent with the intent of the legislature as played out in its public meeting? And I think that would be an important step. It would rein in what happens in the various agencies a great deal. because a lot of what happens is simply by fiat. And I think it would be very important, and it would increase the legitimacy of what they're doing as well. Because a lot of it has to do with, loose interpretation.
Forrest?
Follow to that though, if the implementing legislation by Congress has so little substance, so little direction, how are these commissions going to work off of that?
Because even though, and this is the crazy thing, even though there's not that much substance to them, there's enough to know that a lot of what's going on isn't right. And wherever you stand on the Title IX letter, that's one of the instances.
So what this has already come up before, but I'm not sure I heard what your opinion of the feasibility of this idea is. The idea that administrative agencies can still exist, but all they can do is recommend to Congress that they pass whatever the agencies in their area of expertise ask Congress to pass.
Mm-hmm.
Then that would restore Congress's control over lawmaking. I think is that proposal in your book? I can't remember. Okay. So what do you think of that idea? Would it in fact, would it be an improvement over what we have either substantively or in terms of the rule of law? Just what do you think about that? I think it's an interesting transitional idea, and as someone already mentioned, suggests that this, at least a step in the right direction, wouldn't be so radical as to abolish all the agencies. They would still exist. They would still be doing what they're doing. They just couldn't bind the citizenry without Congress buying into it. What do you think of it?
I think in order for it to make any difference, we do have to take one step further from that, which is they have to come under the authority of the houses of Congress. Basically, committees. They would basically become a research arm for the committee. They would be the ones proposing what the committee would then pass on and make into law. Then the other thing that would have to happen, I think is absolutely essential for the rule of law, you would have to transfer enforcement out of these agencies. This would have to be an executive function that is basically under the DOJ, which would obviously have to increase exponentially, and there'd have to be branches to take care of things, but it has to be recognized. This is prosecution. Because potentially, right, you can have your livelihood taken away from you. I think it's much more important to have it in the DOJ, where there'll be a recognition of the rights that are involved and the need for proper due process.
And due process would include an Article 3 judicial proceeding before you could be deprived of life or liberty.
I would hope so. And putting it in the DOJ emphasizes that.
That's what Philip Hamburger was proposing last night. I heard him lecture last night on administrative state. What do you guys think of this? How does this idea strike you? I mean, I'm sure this is a new idea. Does this strike you as plausible, sympathetic, desirable, undesirable? Sam?
I think my first thought is that it would almost have to be accompanied by changes to what we always reference as the formalist parts of the country, 2 senators per state or something, where I could see it being more conceivable if there was a large increase in the amount of senators and congressmen that would just be able to handle and go through. I mean, if these agencies were basically research arms that were making recommendations, given that they spend 8 hours a day fundraising, there need to be so many more of them to be able to.
They wouldn't do it anyways.
They wouldn't do it anyways. Get rid of the FEC, and then you won't have to spend so much time fundraising. But let's get some other input before we on this idea. Garrett.
I think, as I said before, I think it's abstract, a really interesting idea, but I think they all are just so bad at everything they try to do that this would be like so much more that we would want them to do. You guys spoken like a true progressive, but it seems like they already have such a hard time filling their daily duties now. To ratify all these decisions seems implausible to me.
Simone?
I'd like to defend the people over there just a little bit, because they already do attempt. I mean, there's senators that are commissioning reports from various agencies already, and I think that if they were able to do so from the actual independent agencies, which would then be a part of Congress, I think they would utilize that. I think the danger then would be trying to keep those bodies from becoming political, because right now the problem is that senators get a pre-order of the report and they say, okay, I'd like this to be shifted a little bit before it goes public, which is insane to me. But I think that if you were able to keep it as a nonpartisan body, I don't see why the senators wouldn't rely on it and the Congress people wouldn't rely on it, because they're already doing that in just a much less fleshed out way right now.
James, did you want to say something?
I just had a question that was kind of brought up actually in your book that's on the same topic, but let's imagine that you were to sort of eliminate these agencies and some of the work that they're doing, or accept the fact, as Garrett said, that if we put it on Congress, it's just too much work. So that would then ultimately kick back a lot of the regulation to the state, as you said today, right? Wouldn't that just admit of 50 administrative state governments that are running around the country, or how would you solve it there?
Obviously, one of the things that one would hope would come out of this, we'd have most of this just would stop being there. Most of regulation is in fact harmful to the economy and to human flourishing. But if it goes back to the states, it's more likely that people don't bother voting for state officers, let alone local ones, because they're convinced it doesn't matter. Okay? And the reason they don't think it matters is because, for the most part, it doesn't matter. Communities and even state governing structures have to have a reason to exist. And so much of the reason to exist of state governments has been sapped by the federal government, but I think it's warped all of our views of what is possible at the state level. And I include mine. It's only because I've worked in both state and federal government, and really, yes, they are not as competent, not as concerned, more corrupt, all these other things, but a lot of it is because they're really not doing that much, and there's really nobody watching them. So it would perhaps be the reinvigoration of state and especially local government that we need.
So I think we haven't heard from James, Andrew, and Drew. So which one of you guys?
So you're on the spot now.
I had a question about something you were saying earlier and something in the conclusion. You alluded to the conclusion you talked earlier about how sort of a breakdown of the welfare state could lead to a segmenting of the country, or at least a decentralization in some respect, and maybe a return to a more associational communitarian culture. Do you think it would really take like a breakdown of that size to actually lead to sort of a retreat from a more individualistic culture to a more communitarian one, or is it more cyclical, more of a cyclical trend? And if it was to return to that, do you think that sort of fixes the divide between the written and the unwritten Constitution there?
I'm not sure about the last part. Can you clarify that?
So if there was a return to a more communitarian associational culture, how much does that fix the issue of constitutional morality and sort of bring us back into compliance with the written Constitution?
Before or after the war ball gets stalled? There obviously would be huge dislocational problems if it were to come about that way, right? So I'm certainly not saying that's a good thing, but again, I know people who claim this is inevitable, this is what's going to happen. I don't actually believe that. I think instead of that, we're going to become more and more like a third world country over this. We're going to become more and more like India, okay? Which is to say that the government is in a constant state of crisis. It can't really do much of anything for anybody. You do have some pockets where people are doing really amazing things on their own, despite what the government is trying to do to them. But you have a massive population which is treated horribly. And the state simply is not competent to take on its roles. I think that's the way, that is to me the natural endpoint of social democracy. That's where it ends up. You can look at Venezuela and see how quickly that can happen. But so would that happen to bring this out? If there were a quick breakdown, it would be very difficult because our local institutions have atrophied so much. That's why it's much more important to do it.
Sort of more on a potentially optimistic note, if that hasn't happened yet, is it because there is more residual constitutional morality there than a pessimist might admit, that there still is enough there to keep us from that fate at this time, even if we're moving in that direction? I'll take a maybe. Andrew?
I just kind of moving off of that. So, yeah, if that's not going to happen, why wouldn't that give rise to something like, nosing, like Rothbard would say, and allow the market to just allow those communities to like empower one another, just fend for themselves?
Because of force and fraud.
Is what?
Force and fraud.
Force and fraud, you said. What does that mean?
Yeah.
If the institutions of authority suddenly disappear, the problems you're going to have, there will be people who attempt to dominate through the use of force and fraud because they're no longer kept in check.
But isn't government already using force? Like, what's the difference?
Government is centralized. The government does not actually actively try to take over particular neighborhoods. I mean, if the center goes, then what you're going to have, if there's nothing to take its place, is much more localized, much more extreme violence as take place. I noticed a nod there, and since I have friends in Brazil, one of the things, the problems that happens if the center doesn't hold is that you end up with our own form of non-governmental organizations, otherwise known as gangs. They tend to come out of the woodwork. So I would not at all say that this is something that we should look forward to, that it collapses in that fashion. Now, it's possible that the state and local governments would be in a position to take over from that, but I just don't think that you create ordered liberty out of chaos. I think
So you're basically referencing either Lebanon or Somalia or places where the central government has collapsed, but it wasn't replaced by a polycentric legal order, replaced by gangs. I mean, only the court militias and other names for gangs. That's what replaced it, given that the nature of that collapse. It was not replaced by a Rothbardian or Nozikian state. Situation. I didn't mean state, situation. Drew? You're the last man here.
I guess I have a question just about somewhat of this idolization of voluntary associations. It sounds like very like Herbert Hoover.
Very what?
Herbert Hoover. And like trying to foster private actors to act, especially in times of crisis. And I think of like an economic crisis, say like the one in 1907, and the bankers, the association of bankers come to the federal government and say, we need a commanding structure so that we can have a lender of last resort, so that we can, I mean, I imagine they didn't think we can depend on Congress to like regulate interest rates and
didn't work out too well in 29.
And I just wonder if, in addition to that, there's also, if you revert to this more association-based, it seems like maybe this is also a very progressive thought, but you also run the risk of maybe like refactionalizing the United States, whereas a lot of folks now don't consider themselves to be like first and foremost a citizen of their state. I think some folks do, and I'm from Texas, so I understand that folks do. But it seems like you also give up some consistent rules, even from state to state. And so I guess that's a two-part question of both of how you see that maybe working out, and if that's a positive thing.
Well, to the extent that there's hope, it's that instead of having a sudden collapse, if this were to be a matter of reversion over time, you'd have a chance for people to rebuild these things. Yeah, I grew up in California. I still miss it, even when I'm there. But, I lived in, no rim shot, nothing. But I've lived in 24 states, so I am, completely deracinated. And in any event, I only lived in these incredibly sterile subdivisions the whole time I was growing up, so it's pretty much the same. So I have the typical, middle-class white upbringing, right? And very much uniform. But there used to be, and this is, if I'm going to dump on the people of the late 19th century, It's the insistence on creating national markets did a lot to break down the capacity of states to be different and people to identify with them. And yeah, one of the things that has to happen is that people stay closer to home before it's going to matter to them where they are, who they vote for, and so on. That a lot of what I'm talking about is actually social breakdown. Yeah. Are those things matters of government? I think some of them are. Some of them are. Some of them are just choice, but some of them are have to do with government policies aimed at economic efficiency. So yeah, that's part of it. Do people identify with their states and localities any longer? You know, now I live in one of the poorest parts of the country, actually, burnt out, formerly industrial Ohio. Okay, I live in a city that used to have 35,000 people in it. It's got 17,000 in it right now. There's a lot of abandoned buildings. The people who are still there, most of them have been there for 8 to 10 generations. A lot of them came in the 1840s. Okay, there's 6 families. Everybody seems to be related to each other. Okay, these places still exist. They're in very sad shape, and a lot of opioids. So I'm not saying that they necessarily have everything that it takes. But I still, my point would be that whether it's the thick local ones or the ones that, you know, everywhere I went, I still was a Catholic, I knew where I was going to find certain things in my life, including certain forms of community, that those two together are inescapable. Robert Nisbet always said, if people don't have community, they will have ersatz community, which means ideology, politics. And I think that's the point of it. We have certain drives that are going to happen one way or another.
Can I ask a follow-up question to that? Just, is there no community in being a United States citizen, first and foremost? And secondly, if you have an opioid epidemic, as you've referenced, and it only impacts a portion of states, and it's theoretically possible for the other states and associations to say, I mean, that just doesn't affect us. We don't want to spend money on that, or states broke also. Then it seems like you come to an impasse.
Okay. 2 things. I would argue that a lot of the problems we have is that we're trying to have a national community, and that's just not possible because the relationships are too distant. They're only defined politically, and that's the problem. The flip side of that, does this mean we then abandon people by not having a national solution? One of the arguments against the kind of extensive safety net that you have in social democratic countries that we're developing here is that it fosters the death of community. That, again, communities have to have something to do, otherwise they die off. You know, frankly, I don't like most of my neighbors, but I have to deal with my neighbors because I want to keep the property values up, or right? You see the kinds of arguments, my neighbors are fine. But that's the way it is with a lot of people. You need them, so you need to deal with them on a daily basis. And if you take away that need because they can get it through the mail or from the feds, then it's going to die. That's the argument anyway, whether you buy it.
Caroline? Thank you.
I sort of wonder how the rise of technology sort of dovetails into your argument in that it's not just the social safety net and the welfare state that's giving communities nothing to do, but it's also the fact that I can get all my needs through my telephone. And I wonder if that sort of underlies our new constitutional morality and is part of what makes the current constitutional structure exist.
Yeah. I would argue about it a little bit because I don't think that technology is fate. Okay, it depends. We choose how we're going to use it. Given the way that we approach politics in general, given the way that we approach our communities in general, we buy everything. It was from Amazon until fairly recently when we decided to cut ourselves off and try to give other people our business, because the stores around us suck. And they tend to be run by people who I don't really want to deal with that much, so I guess I don't like my neighbors. But if the locality is more functioning, then we wouldn't resort to that as much. And if we were more virtuous, we'd work harder to do that. So I don't think it's not destiny. But clearly, in our current situation, yeah, it pulls us apart. And, you know, in a family like mine, you know, the kids weren't allowed, no cable, all that other sort of Amish stuff that you've heard about from some people. That was my household. So it's part of it's how you do it.
One of the things that doesn't come through when you read a lot, this isn't so much in your book, but in other social conservative stuff that is in the same kind of ballpark, when you talk about how terrible things have become, and society's in decline and all the rest, is that a lot of things seem a lot better than they used to. I mean, I'm older than you. I'm old enough to remember other things sucking pretty much than the ones that suck today. I mean, it wasn't so necessarily wonderful. There are a lot of ways in which life is better. Now,
antibiotics, painkillers, I'm all for
them. I mean, I think there are upsides to the most recent thing, social media. We have really no idea how this is really going to affect the culture because it's only existed since the day before yesterday. But we have inexpensive travel. People can travel a lot. I mean, I didn't take my first plane ride till I was a freshman in college, and that was like a huge deal. Now people just start jetting all over the place. I'm going to get to a downside in a second, but now I want to just focus on the upside. You've got a tremendous diversity of cuisine. I mean, the idea that you can espresso coffee anywhere, you get a bagel. You get a bagel in the South. You can get Dr. Pepper and Mountain Dew in the North. Which originally was just a characteristic Southern drink. Both of those. So there's a tremendous diversity of culture, not necessarily moral culture, but these other things we get the benefit of. All kinds of things like this. Individual liberty and choice, in many respects, and in good ways, not the liberty and choice to use opioids, but the liberty and choice to live your life the way you wish and to achieve a career path that you want exists now in a way that it may not have existed in the past when it was really reserved. When Columbia was adopting affirmative action in order to, or quotas in order to keep Jews out, they adopted certain kinds of testing because they thought Jews would do worse on it, and therefore that was the key way to keep the Jewish population out of the Ivy League. That was not such a wonderful time when that happened. So all of this now I am prepared now, having heard a lot about this over the last couple of years, to acknowledge that these communities that you're talking about are in some respects being left behind or being isolated, and there's something wrong. There is a downside to all of this upside, and that downside needs to be addressed. And I honestly don't know how to address it. The opioid addiction problem in these communities, and predominantly white communities, is a symptom of something bad that is in fact going on. And I'm prepared to acknowledge that it's a possible side effect of the good things that are coming on, which is you have the development of a knowledge class, which is now empowered and doing very well, and we are all in this room members of it. And if you're not in the knowledge class, you're in the lower class of some kind, and you're not doing as well, and then it may be that your only refuge is drugs, or you think that's what it is, etc. So that's a downside. But don't you think that, given all that, shouldn't maybe we adopt a more balanced view of how bad things are, and so that we can focus on the negative, what I think I would acknowledge to be the negative aspects of the positive, rather than to fail to acknowledge the positive. That's what I'm trying to say.
Everything is bleak. We're going to hell. In fact, we're already there, and there is no hope. Why is this a problem for you? Seriously, I think part of it has to do with different valuation of things. The diversity of consumption opportunities, I don't think it's all that important. I don't think it enriches my life all that much. I enjoy it, but I still can't get decent Chinese in Ohio, let me tell you. And I'm surviving. So that's part. The part about discrimination, yes. That was obviously a terrible thing, but I don't see a lot of racial peace over the last 8 years. I think this has become a problem, where identity politics are the flip side of this. What I wish we had was, when you look at, the Chevy Chase Country Club, my wife used to nanny for a guy who lived right next to her. Big, beautiful thing, Protestants only for many years. You go 2 blocks down, Catholics built a bigger one. That's what I wish we had. Okay? If you want to be a jerk, we'll do something better. Columbia said no to Jews? Brandeis. Okay? There are ways that communities can deal with these obviously bad things. Do we still need to address them? Yes, there are abuses. Okay? But in addressing the abuses, I'm not saying we shouldn't address them through law. I'm saying we have to address them through law constitutionally. But I'm saying that we have in functioning communities ways of responding to them that are healthy. And we need to build on those instead of thinking that rewriting all of society to make it a matter of fairness as described by an abstract set of propositions has to be imposed absolutely everywhere. Because that, by nature, destroys communities, including the ones that people need, especially if they're poor, especially if, historically speaking, they've been trod upon.
At this point, that's a great note on which to end. You get the last word here. And I want to thank Professor Frohnen for coming in.